Good morning, my lord.
I'm sorry, good morning. I'm just getting my,
Sorry, my lord.
my screen up. Thank you very much. Good morning.
My lord, I was coming to the end of my submissions on the first reason why we say that the approach of the Court of Appeal and the appellants to the construction of the Hague Rules was wrong, namely that they got Article 2 wrong.
Mr. Ray, can I just ask you a few questions?
Yes, certainly.
So, you submitted yesterday that Article 3, Rule 6 is outside Article 2.
Yes.
It's not a responsibility or liability or right or immunity,
Yes.
as they're referred to.
Yes.
What if you're wrong about that?
If I'm wrong about that,
Yes.
then we say that you still should construe Article 3, Rule 6, the time bar, as widely as possible, and that given its purpose and its language, it should still lie outside the period of responsibility, if I can call it that, in Article 1E and Article 2.
Right. And is that the way you put the case before the Court of Appeal, is Article 2 argument?
We put the case before the Court of Appeal in a number of ways. Firstly, we said that Article 2 did not apply to Article 3, Rule 6, but we also said that Article 3, Rule 6, in any event, given the width of its language, was not bounded by Article 1E and Article 2.
Right, okay. I mean, there seemed to be an argument before the Court of Appeal that custody and care covered misdelivery post-discharge. It's referred to at paragraph 45 of the Court of Appeal.
Yes, that was a further argument.
That's not an argument you're pursuing.
That's not an argument which we pursue here, as is made clear, I hope, in our case.
Yes.
And that argument was really seeking to support, as best we could, one of the reasons relied upon by the arbitrators,
Yes.
which was that...
Which was that?
Why should custody and care be between loading and discharge? Why can't they be also at either end as well?
But you're accepting that all those operations referred to in Article 2 do relate to the period of loading to discharge?
We do, my lord, and on authority we have to.
And next, I just want to be absolutely clear what your case is on Article 3, Rule 8, and whether you could provide for a lesser time limit post-discharge but before delivery.
Yes, my lord. My lord, we submit there are two questions for the court. The first question is Article 3, Rule 6 time bar restricted to liabilities only from loading to discharge?
Yes.
If we're right that it isn't, then the next question is if it applies to all liabilities incurred under the bill of lading up to and including delivery, can it nevertheless be contracted out of by the carrier in relation to the post-discharge period or the preloading period or both? And our submission on that is that it can be, and it can be for these reasons. Under Article 3, Rule 8, any clause lessening such liability otherwise than as provided in this convention is void. So,
Yes, you're founding on the words otherwise than provided in these rules, which you say brings in Article 7.
my lord, yes.
Yeah.
And so, because Article 7 is so strongly worded, which starts with the words nothing herein contained, then it would be difficult to imagine that the time bar cannot technically be contracted out of at either end, because pursuant to Article 7, one can contract out of all liability altogether in express terms as sought. So we submit that the position is as follows. There is an ability to contract for a lesser period outside the physical operations, there's an ability to contract for a lesser period in relation to loss and damage in relation to custody and care before loading and after discharge, to follow the words of Article 7. But that ability to contract out does not affect the position if there has, as here, been no contracting out. So the position here is that the court is applying Article 3, Rule 6, we say, unfettered by Article 1E and Article 2. One can contract out of it, but it hasn't been contracted out of, and therefore it has its full force and effect.
Whether you're right or not about Article 2, it does seem to me important that Rule 6 is obviously intended not only to cover obligations that arise under the Hague Rules themselves, but contractual and tortious obligations, because it wouldn't be much use to have all claims extinguished after a year if the claimant could still pursue a claim for breach of contract. Let's say the goods are delivered short period after discharge. Don't want him popping up 5 years later and saying, well, I've got a claim that for breach of contract that arose on delivery because you failed to deliver the goods as promised. And it's not time barred because the time bar cuts off at discharge.
Absolutely, my Lord. And the reasoning which underpins Mr. Foxton QC's decision in the Al-Hani that Article 3, Rule 6 is not bounded, as it were, by breach of the obligations of Article 3, Rule 2 and Article 3, Rule 1, applies equally for situations which occur after discharge. And in our submission, that is the importance of the wording in Article 3, Rule 6. In paragraph 1 of the Notice of Claim submission, which I discussed yesterday, and then Article 3, Rule 6, paragraph 3 with the time bar, all focused on delivery and cutting things off at delivery.
Because that's when most of your claims arise, actually. Many of your claims arise. Any claim for breach of contract will arise on delivery, will it not? Whether it's for loss or damage or misdelivery.
Well, it may arise.
Failure to, well, you may have a claim relating to earlier times, but you'll have one anyway for failure to deliver the goods as promised. Failure
to deliver the goods as promised, and in the condition described in the bill.
Yeah.
And that fits in with the Notice of Claim submission provision in paragraph 1 of Article 3, Rule 6, which is trying, as it were, to legislate for that situation. So I hope that has clarified where we were. Not quite so clearly at the end of yesterday afternoon.
And you were going to answer my question about
yes,
Article 5.
I was. Sorry, I was going to answer your question. So that answers my Lord Hamlin's question and the question put to me yesterday by my Lord Richards.
Yes.
In relation to Article 5, Article 5 is a pendant, we submit, to Article 3 and Article 4 and uses, in our submission, the same terms as are used in Article 2 with the same meaning. So he can surrender his rights or immunities, and we say they're the rights and immunities under Article 4, or he can increase his responsibilities and liabilities, and those are his responsibilities and liabilities, his obligations under Article 3. And so the scheme is Article 2 imposes obligations upon the carrier in relation to the given operations. Those obligations are found in Article 3. It also entitles the carrier to have immunities and rights in relation to those obligations. That's in Article 4. But there was a concern at The Hague that carriers who wanted to be more generous would find that they were in some way prevented from being more generous because of the specification of the obligations and the rights and immunities. So Article 5 was put in.
But surely you can, amongst other things, you can agree to surrender or reduce your right for extinction of all liabilities after a year. You could agree 2 years.
My Lord, one can do that, but that's not a situation. One can do that in any event. You don't need the convention for that. But that's not a situation which is dealt with by Article 5, because we say rights and immunities is used in the same way as it is in Article 2, and responsibilities and liabilities in the same way as in Article 2. And
I can't see why rights and immunities in Article 2 doesn't include Article 3, Rule 6. It's a right or immunity of the carrier.
Well, my Lord, I see that, but...
Amongst others, of course, the ones in Article 4 as well, but another one you've got is that all liability is extinguished after a year. That's quite an important immunity.
It is, my Lord.
And indeed a right.
And a right, yeah.
Right. And I'm happy in one sense that if I'm right on Article 2, then Article 5, of course, the carrier can increase. But it's interesting when one looks at the debates at The Hague, they saw Article 5 slightly differently. Can I just take your Lordship to a passage in the Travo, which is at core volume, page 1272. It came at the end of the discussions in the one of the final plenary sessions.
Can you just give the page again?
I'm so sorry, my Lord, I do apologise. 1272.
Thank you.
The chairman, this is Mr. Louis Franck at this stage in 1923, was having to deal with a point made by Monsieur Ripert, the French delegate, who raised a very complicated question about the word entitled in Article 4, then called Rule 4, and that was not followed up. But the chairman says this: Mr. Chairman, the chairman declared that Mr. Ripert could withdraw his objection to Article 4 if, having viewed the text, he considered that one could dispense with the insertion of this paragraph. But he would perhaps appreciate that the Convention's economy was, on the one hand, the shipowner accepted liability for a group of obligations and renounced his contractual freedom. That, in our submission, is referring to Article 3. That was his sacrifice. On the other hand, he obtained the incontestable and uncontested right to exonerate himself in a number of cases in which he was otherwise responsible under law. And we say they're talking there about Article 4. The obligations of the shipowner are listed in Article 3. His rights are set out in Article 4. And all that Article 5 says is the shipowner is considered to be the stronger party and that it is against him that this legislation is designed. If he wanted to accept a position worse than that accorded to him by the Convention, he could not be prevented from this. So it seemed that Article 5, at least in the minds of the drafters, was tied to Article 3 and 4.
But your suggestion there's a sort of watertight restriction of rights and immunities to Article 4. I mean, what do you say about Article 3, Rule 5, and the right to indemnity, which they're provided for?
Sorry, I'll just turn back the text.
This is against the shipper.
Well, my Lord, that wouldn't fit with my submission.
No. I mean, I think in general terms that's clearly right to say they're set out in Article 4. I'm not sure one can say that's definitive in itself.
Well, all I'm saying, for my purposes, it's enough that the Article 3, Rule 6 time bar is not a right or immunity or a responsibility or a liability. And we submit, for the reasons I gave yesterday, that it's not within the scope of what was intended to be covered by Article 2. My Lord, that brings me to an end almost of what I wanted to say in relation to the Article 2 construction point. Two short points. First of all, a word about the headings. The headings were used to define Article 3 and Article 4 in all of the drafts of the Convention from 1921 right up to 1923. But when it went, as it were, for diplomatic drafting to make it into a treaty, the headings came out. And therefore, you're considering a treaty with the headings out. The parliamentary draftsman, when drafting the Carriage of Goods by Sea Act 1924, put them back in, but perhaps more faithful to a treaty, the parliamentary draftsman for the Carriage of Goods by Sea Act 1971, when appending the Hague Visby rules, leaves the heading out. And there's a typographical error, I'm afraid, in our skeleton argument, our written case, which omits the not in relation to the Hague Visby rules. And that's at paragraph 82 of our case, at page 73 of the key documents. That's the first point I wanted to make. And the second point I wanted to make is that, of course, the court will be construing Article 2 in light of the object and purpose and the context. And I don't want to go back over many expressions of what the context and purpose was for these provisions. Can I just remind the court where we set those out in our case, which is at paragraphs 91 to 95 in the key documents bundle, pages 75 to 76. And we set out there a selection of citations where those principles are explained. My Lord, those are our submissions on the first reason why we say the Court of Appeals and the appellant's approach is wrong. The second two reasons, second and third reasons, I can take rather more quickly. The second reason is that they fail to take account of provisions in the Hague Rules which do apply before loading and after discharge. And we've looked at those provisions already, so I won't go back over them. In relation to after discharge, we've got the provisions in paragraphs 1, 2 and 4 of Article 3, Rule 6. Before loading, but simply after receipt of the goods by the carrier, whenever he receives them, there's the obligation under Article 3, Rule 3, to issue a received bill of lading, which is subsequently replaced by a shipped bill of lading after loading takes place under Article 3, Rule 7. The third reason why we say the approach are the uncommercial and unlikely results of the approach, which make it unlikely that the drafters of this time bar, given the language in which they drafted it, intended it to be dependent on fine distinctions and splits in regime. That's been emphasised by the court in numerous cases, and I've taken the court to some of them: the Captain Gregos, the Otis Sonia, the Alhani, and the Aries. It's also well emphasised in the Obiter judgment of President Kirby in the Australian case of Ji Jiang Ku, and perhaps I can take the court to that in this context, which is in the core volume at starting at page 1167. With the relevant passage in the judgment of President Kirby, starting at 1189. This, in our submission, is an important counterpoint to arguments the other way, and that's why this case and President Kirby's judgment to this effect is cited in many of the commentaries, or referred to in many of the commentaries. So if I can pick it up at the bottom of page 1189 in column 2. Leaving aside authority on the point, the suggestion that the Hague Rules, and in particular Article 3, Rule 6, should have no application to events occurring after goods go over the ship's rails and are discharged appears on the face of it unlikely, given the purpose of the Hague Rules to govern the incidence of sea carriage of goods. The argument is doubly unattractive when the very word language of discharge from liability referred to in Article 3, Rule 6 is considered. It is most unattractive of all when consideration is given to the practical implications of so holding. Some of these were analysed by Mr. Davenport, QC, in his notes, Limits on the Hague Rules. And then if I can just ask the court to read the first cited paragraph, which comes from Mr. Davenport's article, starting the approach could. And then, if I I may I take the court to page 1191, where the President said the court was not bound by any of the decisions, in particular Rambler.
Where's this?
I'm so sorry, my Lord. It's the top of page 1191, column 1, left-hand column. So just at the top of the page, he's citing
Yes.
the Rambler cycle case in Malaysia,
Yes.
which I'll come to briefly in a moment. The court is not bound by any of the cited decisions. In the Captain Gregos, when it came to the English Court of Appeal, Captain Gregos was a Hague-Visby Rules case. Lord Justice Bingham was at pains to emphasise the very wide language of Article 3, Rule 6 of the Hague-Visby Rules. His Lordship's observations imply equally to the almost emphatic language of Article 3, Rule 6 of the Hague Rules unamended. And then he cites Lord Justice Bingham. I do not see how any draftsman could use more emphatic language. It's even more emphatic than the language Lord Wilberforce considered all-embracing in the New York Star. Like him, I would hold that all liability whatsoever in respect of the goods means exactly what it says. The inference that the one-year time bar was intended to apply to all claims arising out of the carriage or miscarriage of goods by sea under bills subject to the Hague-Visby Rules is, in my judgment, strengthened by the consideration that Article 3, Rule 6 is, like any time bar, intended to achieve finality, and in this case, to enable the ship owner to clear his books. While it is true that precisely the same question now before this court, as this court was considering the Hague Rules, was not under consideration in the Captain Gregos, the reasoning of all of the Lords Justices and their emphasis upon the breadth of the terms of Article 3, Rule 6, its practical purpose and the generality of its operation all run counter to the suggestion which the Respondent urged on this court. And we submit that is sound and helpful. Lastly, on commerciality and the unlikelihood of fine distinctions and split regimes, can I remind the court of how the three arbitrators assess this issue, of what sort of results confining Article 3, Rule 6 in the way the appellants before them sought to do was unattractive. If I can ask the court to go, please, in the key documents bundle to page 213. There are 4 paragraphs which we rely upon, and to spare my voice, perhaps I can ask the court to read them to itself. They start at page 213, and they're paragraphs 125, 126, and 127. My Lord, for those 3 reasons, the incorrect construction of Article 2, the omission to consider provisions in the rules which apply outside the so-called period of responsibility, and the unlikelihood of that being the intended result of the draftsman, given the language used and the problems which it would produce, we submit that the Hague Rules time bar is not confined to liabilities arising up to discharge only. There are three other matters I need to deal with in relation to the Hague Rules, given matters relied upon by the appellants, other than the language of the rules themselves. First of all, the English cases on period of responsibility. Secondly, the travaux preparatoires for the Hague Rules. And thirdly, the alleged international consensus. I can take the period of responsibility cases in English law very shortly. The court looked at them yesterday, Goss, Millard, Pyrene, Scindia, the Arawa and the Al-Hani. They don't touch on the point this court is considering. And when it is borne in mind that the concept of the period of responsibility corresponds perfectly with the creation by Article 2 of the irreducible minimum of Article 3 obligations and the maximum exceptions and rights in Article 4, both posited on the loading to discharge operations, then sweeping statements as to the period of responsibility tell one very little. And they're equally consistent with our case as with the appellants. And the same goes for the second point, the travaux preparatoires, because most of the discussion in The Hague was on the tackle-to-tackle principle. And we've just seen in the travaux preparatoires how it was put. The carrier sacrificing his freedoms by undertaking, as Mr. Frank put it, his sacrifice, because he has to accept certain obligations which he never had to accept before, and also accepting and getting the benefit of certain exemptions which he might not have had before. And therefore, the concentration on the tackle-to-tackle principle, as it became the loading-to-discharge principle, again tells one nothing about Article 3, Rule 6 and the time bar, which was drafted in very different terms. That brings me on to the international consensus. I've taken the court already to the Australian obiter judgment in the Jiang coup. The important thing about the international consensus, is not just the result which a court arrives at, but the reasoning and the route by which the court arrives at that result. If the result that Article 3, Rule 6 time bar only applies between loading and discharge is based on reasoning that this court does not accept and has not accepted, then the result is really nothing to the point. And in our short submission, the Malaysian cases are flawed for precisely that reason. They come from the old line of cases and the old line of thought that the Hague-Visby rules and the time bar in the Hague-Visby rules applies only to breaches of the Hague-Visby rule obligations. That is not the position in this country, since the Captain Gregos and reaffirmed in the Al-Hani. And that was the most important factor for the court in Malaysia, is clear from the Rambler Cycles case. And if I ask the court to go to that, it's in the core volume at page starting at page 1195. And the judgment of the court given by Sir James Thomson in relevant part starts at page 1199. And in the 1199 in the right-hand column, James Thompson says in the second paragraph, to proceed, it seems clear as a matter of construction that paragraph 6 can only refer to claims in respect of loss or damage arising by reason of the provisions of Article 3, and that Article 3 in its turn can only have application within the ambit of the Act as a whole. The real question here is as to the extent of that ambit, and so to what liabilities the limitation contained in Article 3 applies, or at any rate whether it applies to the liability which has been incurred by the present appellants. And then he cites it. Next paragraph, the conclusion seems inescapable that the loss or damage which is referred to must be loss or damage resulting from failure by a carrier to discharge the responsibilities and liabilities set out in Article 3, and this in its turn is to be read in the context of the Act as a whole. And then if one goes on, at the top of page 1200, approached purely as a matter of construction, all this leads to the conclusion that the Act has no relation to anything that happens to goods after they are discharged from the ship in which they've been carried. So that is the route by which the court gets to its result. And the same route is followed by Chief Justice Wiley, Chief Justice Wee, at page 1202. I've had the opportunity of reading the judgment, 1202, right-hand column, just after the middle. I've had the opportunity of reading the judgment of the Lord President, and I agree with the conclusion he's arrived at, that the Hague Rules of Matter of Construction cease to apply after the goods are discharged from the ship. And then he gives his own reasons. He sets out Article 2. Article 2 is therefore the article that gives the carrier all his rights and immunities, including the right to be discharged from all liability, Pyrie and Incendia. The loss or damage in paragraph 3 of Article 3, Rule 6, on which the appellants rely, must therefore, in my opinion, be loss or damage in relation to the loading, handling, stowage, carriage, custody, care and discharge of such goods. And Chief Justice Wiley, I think, says nothing very different. So in our submission, the Rambler Cycle case is, as it were, good for the result, but wrong for the reasoning. And the Min Metals case, which simply followed Rambler Cycles, doesn't take the position any further. So that means that the case law in Malaysia is not of assistance to the court here, because the central premise upon which it rests is not a premise that this court has adopted. That leaves Australia, and in our submission, the Australian cases by themselves may be looked at, of course, by the court for guidance, but they don't fall within the bracket of international consensus being the courts of one country only. And importantly, in all of the cases cited, Rambler Cycles is regarded as important. So we would submit that this is not a case where there is a clear international consensus on what the result is and why that result flows from the proper construction of Article 2. In those circumstances, they are of no assistance to the court and should not lead the court to a result other than that which we contend. My Lord, that's all I wanted to say about the Hague Rules. I now come on to the Hague-Visby Rules. And there are four matters to consider here. First, the text. Secondly, the travaux préparatoire. Thirdly, the commentaries. And fourthly, two Hong Kong cases.
So we're assuming you're wrong on the Hague Rules for this purpose, are we?
Well, my Lord, if we're wrong about the Hague, if we're right about the Hague Rules, then the Hague-Visby Rules don't matter.
No.
If we're wrong about the Hague Rules, the Hague-Visby Rules do matter.
That's right.
But in our submission, there's a third position, which is the court will be looking to see how the two mesh together. Because what is, we would submit, striking is that in the debates in the travaux, no one thought, when they were asked to consider the specific aspect of misdelivery, which occurs almost always after discharge, and discharge precedes delivery. It's referred to as the paradigm case by the Court of Appeal, and we have passages in Lord Wilberforce's speech in the New York Star, no one considered, but this is a problem really which doesn't arise very often. Why are we dealing with it? Because the time bar doesn't apply after discharge. The time bar doesn't apply to delivery. So why are we having to amend the rules to deal with a problem that doesn't come up very often?
That in itself doesn't really, I mean, maybe a forensic point, but we can't interpret the Hague Rules by reference to what the people at the Hague Visby conference thought they meant.
My Lord, no, and I'm not asking the court to do that, but it is in our submission a cross-check, because, and if that's what the drafters of the Hague Visby Rules thought, and you are concerned with what their intention is, then the fact that a different result pertained under the Hague Rules does not prevent the Hague Rules having a different effect.
The Visby Rules, I mean, Hague Visby
Hague Visby Rules having a different effect. Because the argument against me by Mr. Smith is, well, they can't have intended to change the Hague Rules. Well, the first question is, what do they think the Hague Rules actually provided for? And then I have my Lord Legate's point on that. But secondly, what were they thinking they were doing? And were they seeking to achieve a completely different result, or were they seeking to achieve a result in relation to misdelivery of goods, which is something which carries the position further than the Hague Rules did? Because when one looks at the Travo, and the Court of Appeal were in our submission rightly taken with them, and that's why the commentaries are more in our favour than in the appellant's favour in relation to the Hague Visby Rules. The Court of Appeal were very struck by the fact that the delegates were talking in unrestricted terms about delivery and misdelivery, in circumstances where they can't have been talking about misdelivery occurring only on discharge, only in certain trades. And I'll make that submission, I hope, good when I take the court to the Travaux Prétoire. In relation to the text, we have, I won't take the court back to it, the words are very wide, all liability whatsoever in respect of the goods. And if the wording of the Article 3, Rule 6 wasn't wide enough on its own to do it, in our submission, the wording of Article 3, Rule 6 of the Hague Visby Rule is wide enough to do it. And the Court of Appeal was right to think that the wording was changed and became so wide that it would be idle to say that misdelivery of the goods is not a liability, falling within all liability whatsoever in respect of the goods. But the position is put beyond doubt.
Sorry, when you're on the text of the Hague Visby Rules, there's another aspect of the text, and I don't think anyone's mentioned, but I wondered whether it might be relevant, which is on page 999.
My Lord.
At the bottom of that page, Article 4 bis. I mean, we know that's what the Hague Rules have been interpreted to mean, but it's put beyond doubt, it seemed to me, in the Hague Visby Rules that they're not just concerned with the Hague Rules obligations themselves. They're concerned with claims for breach of contracts and tort as well.
Yes, my Lord, and the important words there would also be loss or damage to goods covered by a contract,
Yeah.
whether the action be founded in contract or tort.
So, I mean, we know that's been found the position under the Hague Rules for us anyway, but, I mean, that puts Rambler motorcycles out of court, it seems to me, for the Hague Visby Rules. We can forget about it.
It does, my Lord, yes. Thank you, my Lord. I'm grateful for that being drawn to our attention. So, my Lord, to the Travo, if I may. The court is in a slightly unusual position in a Travo case, because here the item on the menu, which we saw yesterday in French, was being deliberately given to the subcommittee to go away and consider and do something about. And that was delivery of the goods. I won't try to remember the French. Delivery of goods to a person not having the right to receive them. And so two preliminary observations when considering the Travo, and I think I probably anticipated this already at my opening submissions. Discharge and delivery are two entirely different concepts and constitute two entirely separate acts on the part of the carrier. One is the purely mechanical, physical exercise of putting the cargo off the vessel and ashore. The other is the fulfilment of the bill of lading obligation to deliver the goods up to the person entitled to them under the contract of carriage. Secondly, save in tanker trades and certain bulk trades, discharge necessarily precedes delivery in the vast majority of cases. People taking cargo as it crossed the rail in the carrier's net was pretty uncommon in 1920. By the time people were discussing matters in Rijeka in 1959 and in Stockholm in 1963, it was a thing of the past.
I mean, just as to that,
yes,
in the award to which you took us, in paragraph 126, the tribunal there says, many, indeed most deliveries will be at some point after discharge over the ship's rail. And then they go on to give examples of stevedores acting for receivers. It's only a footnote in a sense, but I'm not sure, the tribunal did not seem to regard it as a sort of theoretical possibility.
I don't know, and I wouldn't say it is a theoretical.
No, I mean, but yes.
Because in certain trades,
They're not talking there about oil and bulk cargoes, are they? No.
There will always be situations where delivery and discharge are absolutely coincident.
Yes.
But in most cases...
Yes. Many, indeed most, is what the tribunal said.
Which is good enough for me.
Yes, it's good enough for you.
Many, indeed
it's
most.
Contemporary.
Yes. And as the Court of Appeal, with their experience of these classes of case, said, misdelivery after discharge is the paradigm case of misdelivery. But your Lordship is quite right to point that out.
Okay.
So, with those observations in mind, and I take the Court briefly to the Travaux Opératoires, and stage one, if I can put it in that way, is the subcommittee's report of the 9th of November 1963, and that's in the core volume, starting at page 1316. And this comes from the International Maritime Committee publication of the Stockholm Conference. And if you go on to page 1319, time limit in respect of claims for wrong delivery. The subcommittee discussed at some length whether and to what extent the expression, the liability, sorry, my Lord, I'm reading from the second paragraph under the heading, whether and to what extent the expression, the liability in respect of loss or damage also covers the carrier's wrong delivery. And then, whereas it was felt that in some countries wrong delivery caused by mere negligence on the part of the carrier's servant falls in the terms of the convention, it was generally agreed that intentional delivery of the goods to a person who is not bearer of the bill of lading is not covered by the convention. And then the second paragraph, were the convention to contain a rule laying down that the time limit should operate also in respect of claims based upon wrong delivery of the goods, again without restriction, such a rule would solve a recurrent practical problem. How long should a person who's received the goods without producing the bill of lading, and therefore has had to put up a bank guarantee, be obliged to keep the guarantee running? The time limit for claim is definitely fixed. This would also determine the necessary duration of the bank guarantee. The subcommittee felt it would be useful and practical to have a rule on this particular point. One great advantage would undoubtedly be that a bank guarantee given against claims for wrong delivery would be reduced to more reasonable periods and would thus actually operate to the benefit of consignees as well as the carriers. And then there's the discussion which my Lord Hodge raised yesterday about whether it should be 2 years or 1 year. And then the decision of the committee over the page, page 1320, provides for the suggested text, which is then sent off for discussion. We have the original wording, and then we have provided that in the event of delivery of the goods to a person not entitled, the above period of 1 year shall be extended to 2 years from the date of the bill of lading. Now, my Lord, in our submission, this is the starting text. It doesn't end up like this for reasons we'll see. But that starting text is clear that it's referring to all cases of delivery of a goods to a person not entitled. And it can't really be sensibly read as delivery of goods to a person not entitled occurring on discharge or before discharge.
And it's perhaps worth pointing out that the sort of reasoning about the keeping the guarantee open seems to be a variant of the closing the books type argument generally.
Absolutely, Lord. And one sees that point taken up by the various national committees for whom it was, especially the ship-owning countries, for whom it was a point of concern. But importantly, my Lord, while the subcommittee was making that recommendation, if one goes over to page 1323, the committee had very well in mind the Article 1E and Article 7 issue. They were having to consider, as it were, the period of responsibility, if I can use that shorthand, and therefore the fact that if the period of responsibility defined the time bar, that would have to be something which would have to be taken into account in redrafting the time bar. And they examined two problems. Should the carrier be made liable for any period before loading and after discharge? And in our submission, all they're considering there is, should the irreducible minimum of obligations and maximum of rights and immunities be extended? And they said no. Could a clearer line of demarcation be drawn as to when a carrier's liability begins and when it ends? In other words, when does loading start and when does discharge finish problem? And they said no, leave it as it is. But they had in mind Article 1E at the same time as they were grappling with the question of wrong delivery of goods. And as I say, no one contemplated, there was no point really in dealing with it because it wasn't really a problem, because time bar never applied, or very rarely applied, or not very often applied to misdelivery, because misdelivery occurred after the critical point of discharge. If I can then take the court to the national committees, and take these, I hope, quite quickly. Page 1327 is from the Finland committee. And again,
and just give that page again.
So sorry, my Lord, 1327.
1327, thank you.
And again, at the top of the page, Finland refers to the problem or the issue of misdelivery in entirely general terms. The carrier now and then delivers goods to a person who has not the relevant bill of lading in his possession. The carrier often does this to accommodate a customer, and in most cases the customer will be able to produce the bill of lading within a very short time. However, other cases are not so simple as this. Whenever, and then the next paragraph, whenever the carrier delivers goods without the bill of ading being produced, he requires a guarantee, or should do so, for his own safety. This guarantee usually constitutes a financial burden on the consignee. He's therefore anxious to get rid of this burden, and if he's bona fide, he will, without loss of time, make arrangements to produce the bill. And so they were considering, again, the guarantee issue, which seems to have been something in the minds of all of the committees. If we go on to page 1330 in the Swedish committee, and this is where, as it were, things start to move away purely from a provision for misdelivery to a wider text which would include misdelivery but which would include other things as well, which is where, as it were, we ended up. So at the bottom of page 1330, our association would prefer a uniform time bar applicable to all types of claims on the bill of lading. This would dispose also of the question of time limit in respect of claims for indirect damage through delay, which would indeed be a great advantage. We would favour a uniform one-year time limit to be introduced covering the whole field of possible claims. We submit that Article 3, Rule 6 should be amended to read as follows. In any event, all rights under the bill of lading shall cease unless suit is brought within 1 year after delivery of the goods or the date when the goods should have been delivered. So wider than misdelivery. The British Maritime Law Association report at page 1334, sorry, reported, it's in the italicised paragraph at the bottom of the page, supported the view expressed in the report that the Convention should contain a rule laying down that a time limit should operate in respect of claims based upon wrong delivery, again, entirely general. This would allow consignees who've received goods without producing bills of lading to obtain bank guarantees for a fixed and probably shorter period, not however considered desirable that varying time limits should be introduced. And so they then suggested a different text at page 1335, which I don't think we need to look at. It's rather more long-winded than the original proposal and the proposal which actually was accepted. Norway is at 1346. Um, 1346 under the heading time limit in respect of claims for wrong delivery. We are glad that a new rule in this matter is proposed by the majority of the International Subcommittee. As we pointed out before, the object should be to fit the rules to the normal rather than the abnormal cases. A far greater number of deliveries to persons not in the position of an original bill are, of course, deliveries to the right person. These are now suffering from the burden of the bail expenditure for too long. Therefore, we can still not see the necessity to extend the period to 2 years. We beg, with respect, to disagree with our Finnish friends, who suggest it's always easy to bring the missing bill of lading forward in a short time. We would also support here the Swedish proposal of one uniform rule covering all claims under a bill of lading. We agree that there is a need for covering also the claims for delay in delivery, because in some countries such claims are held not covered by the expression loss or damage. And then the United States, which I think my friend took the court to yesterday, the United States played an important part, and we see in the debates, which I'll take the court to shortly, Mr. Moore, who is the chairman of the United States Committee, a very large committee, coming to the fore in analysing what the drafting should cover. And we can pick up what they say in 1355. And one has the subcommittee text at the top, which we've already looked at. And
that's the page number again.
So, sorry, my Lord, 1355.
55.
Sorry, my Lord. 1355 under the heading, the subcommittee's text is set out. And if I can take the court right down to the very bottom of page 1355, the American committee said this: the Swedish Maritime Law Association, in its report, has revived this proposal and recommended that the third paragraph of Article 3, Rule 6 be amended to read, in any event, and then delete the words, the carrier and the ship should be discharged from all liability in respect of loss or damage. All rights under the bill of lading cease, unless suit is brought within 1 year of delivery of the goods. Your committee agrees in substance with this proposal, but fears that the language used might be interpreted to prohibit any extension of time, even by mutual agreement. Your committee feels it would be preferable to stay closer to the present language, which had already been interpreted to permit such extensions of time, for instance, by using the following language: in any event, the carrier and the ship shall be discharged from all liability in respect of the goods, unless suit is brought within 1 year after delivery of the goods. the National Committee's reports in, there was then discussion in committee between the 8th and 12th of June. There was an opening plenary session on the 10th of June, which is at 1367. Which has Mr. Moore again addressing the plenary session. The Maritime Law Association of the United States finds itself in a large majority which would simplify and clarify the present rule by specifically making the carrier's liability with respect to the goods subject to a limitation as to time, not only as regards loss or damage, but in other respects as well. And then there was a discussion of the 1 or 2 year period. You were then taken by my learned friend to the Berlingeri Travo, and as I understand the difference between this and the Travo we've just been looking at, which is the printed Travo for the Stockholm conference, the Travo in Berlingeri's book are CMI reports, or are called procès-verbaux, of subcommittees which are not included in the main Stockholm volume. So these are additional materials showing actually what was happening between plenary sessions. And if we go in that, please, to page 1436. Wrong reference, I apologise. Yes, it's 1290.
So which page?
1290, my lord. Mr. Moore says that the subcommittee, having fully considered the question of the time limit for claims by cargo owners against carriers, directs the drafting committee to prepare and submit a draft amendment to the 3rd paragraph of Article 3, Rule 6 of the Hague Rules, such amendment to provide a 1-year limitation of time to sue in the broadest possible terms. And there were then issues raised, as the court saw yesterday, by the French delegation, who proposed a rather different approach. We see that at 1310 in the translation. In case of delivery of goods to the wrong recipient according to the bill of lading, the action against the carrier by the rightful recipient...
Where are you reading it? 1310?
1310, my lord.
Where?
1/3 of the page down. Starting in case of delivery of goods.
This is their proposed text.
That's the French text.
French proposed text.
Thank you.
In case of delivery of goods to the wrong recipient according to the bill of lading, the action against the carrier by the rightful recipient shall be barred by 1 year from the date on which that person learnt of the delivery unduly made. One's not concerned with the details of the French alternative proposal, but what one is concerned with is that even on the alternative proposal, the language was absolutely unrestricted and was talking about delivery of goods to the wrong recipient according to the bill of lading without restriction. And then the two proposals which were put are at 1313 at the top. And as my learned friend pointed out, this translation misses out the essential word whatsoever or quelconque. So we have two proposals right at the top of the page, my lord. First proposal for Article 3.6. In any case, the carrier of the vessel will be discharged of any liability whatsoever, one should insert there, relative to the goods. And the proposal of the minority, in any case, the carrier and the vessel will be discharged of any liability whatsoever relative to the goods within the scope of the provisions of this convention. And the majority had it, and the thank you. The majority approach was adopted, and one sees that, therefore, at the last plenary session on the 14th of June 1963, at page 1369, and it's in 1369, just before halfway down. As regards the third positive recommendation of the International Subcommittee, the subcommittee moves an amendment to the present text of the Convention, more exactly to the present text of Article 3, Paragraph 6, relating to the one-year period for the entering of claims. Interesting how it was regarded. The object of the aforesaid amendment is to give the text a bearing as wide as possible, so as to embody within the scope of the application of the one-year period, even, so not restricted to, even the claims grounded on the delivery of the goods to a person not entitled to them, i.e. even in the case of what we call a wrong delivery. And so in our submission, based on the Travo, which explain why the text was adopted in the way in which it was, and shows the history of the drafting of the text, starting out life as being specifically to deal with the issue of wrong delivery of goods to the person not entitled to them without presentation of a bill of lading, without restriction, how that became widened to cover all liability whatsoever in respect of the goods. But so wide was that wording intended that it would even cover claims grounded on the delivery of the goods to a person not entitled to them. In our respectful submission, when one's applying Article 31 and Article 32 of the Vienna Convention, as the Court of Appeal did, this is, if there is any ambiguity about the text, the amended text, a bullseye, because it shows a definite legislative intention. If there isn't an ambiguity because the text is pretty clear already, then it's certainly confirmatory of it. And so for those reasons, whatever the position under the Hague Rules, in our submission, the Court of Appeal was right to find, as it did, that specifically in relation to misdelivery, as we've seen also in relation to other liabilities, but specifically in relation to misdelivery, the Article 3, Rule 6 time bar was intended to apply to that type of wrong, that type of breach of contract, without restriction. So even if there were a period of responsibility straitjacket for Article 3, Rule 6 under the old Hague Rules, that straitjacket was discarded specifically for the purposes of wrong delivery under the Hague-Visby Rules. And the Court of Appeal was entirely right to reach the view that it did. The only other two matters I need to deal with are the commentaries, and I won't take the Court to these because they are well summarised by the Court of Appeal at paragraph 80. Perhaps I could just ask the Court to turn that up, everyone sees how the Court of Appeal has done it, at page 128 of the key documents bundle. And I won't take the Court through all the citations that are made, but in our submission, the Court fairly summarised the position in this way, at paragraph 80. On balance, the textbooks suggest that the Hague-Visby time limit does apply to misdelivery going after discharge, although this is not unanimous. And I wouldn't put it any higher than that, but I wouldn't put it any lower than that either. My Lord, the only update to that list of references given by the Court of Appeal is an article written by Professor Francis Reynolds, co-author of Carver on Bills of Lading, and we find that in the core volume at page 1460. I apologize, it starts at page 1457. Now, this is another article which is positive in the sense that it thinks the position should be different under the Hague-Visby rules. the limitation with this article is that it was written after the first instance judgment, not after the Court of Appeal judgment. So Professor Reynolds found it, as it were, difficult to identify what he thought was the true ratio of the decision in the first instance judgment. But he concludes, after referring to the Travo at page 1461 and over to page 1462, that should be the position, and he concludes that on the merits, so I'm reading from the second paragraph, it is submitted the effect of the decisions of the Distinguished Arbitral Tribunal and Sir William Blair is both correct and desirable. If there is to be a time bar, it is unsatisfactory if the carrier is protected by it in respect of some claims, but not others. Sorry, but not other similar ones. At one point, it had been proposed to have a 2-year time bar in respect of wrong delivery, but this could, of course, lead to argument, more than once referred to in this context, as to whether what had happened to the goods ranked as lost before the end of discharge or as wrong delivery. A point often made, it was not safe for a carrier delivering the goods without a bill of lading, but under a letter of indemnity to release it and its security before it is clear that all claims against it were barred by limitation. And then saying that it doesn't matter really whether you're considering it from the position of cargo owners or carriers. So we would submit that the commentaries support our position on balance. And that's important. My Lord, lastly, I should deal with the Hong Kong case. And we would say that the Court of Appeal were right to disregard this as any form of helpful authority or set of authorities for the reasons which the Court of Appeal gave at paragraphs 78 to 79 in the key documents bundle at page 127. I'll just ask the Court to turn that up. My learned friend hasn't argued that the international consensus for the Hague rules helps in relation to the Hague-Visby rules, and that argument was unavailing in the Court of Appeal because the Court of Appeal said that the rules are completely different. But the Court of Appeal said this: it is true that there is Hong Kong authority, Chong Yuk Fai, and perfect best asset management. Article 3, Rule 6 of the Hague-Visby rules does not apply to a claim for misdelivery occurring after discharge. However, 2 cases from one jurisdiction are not capable of amounting to an international consensus. In any event, the judgments in those cases did not consider either the significance of the language used in the Visby Amendment to Article 3, Rule 6, or the impact of the Visby Travaux Preparatoires, and that really is the end of it. But it is really quite striking that the Chong Yuk Fai case, which is the only really reasoned decision, was concerned with very extreme facts. If I can ask the Court to look at 1028 in the core volume. At paragraph 50. In the present appeal, the goods were far removed from the situation considered in an earlier case. The goods had been discharged from the Ming Star at Hamburg, so the carriage was from Hong Kong to Hamburg, sea carriage, and had arrived via inland transport at Moscow before disputes at their custody began. On no stretch of the imagination could the goods be said to be still within the scope of a contract of carriage by sea, and that takes one straight back to Mr. Justice Devlin in Pyrene and Scindia. And so 1029, in my view, Article 3.6 could not possibly extend to wrong delivery after inland carriage, and we would agree. But the facts of that case are not really dealing with the ordinary case of wrong delivery by the carrier when the goods have been discharged and are then delivered at the port. So, my Lord, for those reasons, we submit that the Hague-Visby rules, Article 3, Rule 6 of the Hague-Visby rules, the time bar is clear, and applies to misdelivery of the goods whenever occurring. It is not bounded by Article 1E or Article 2 if the Hague rules are so bounded. My Lord, that's the lengthy part of the issues, issue one. The next two issues are rather shorter. The first of those issues is if the Hague rules do not apply and the Hague-Visby rules do not apply, has there nevertheless been a contractual application of the rules so as to govern, or release of the time bar, so as to govern the position after discharge? And there are two alternative routes to that contractual application we submit. The first is the express contractual application of the Hague-Visby rules to the Bill of Lading contract. Now, the court saw yesterday the relevant words in the Bill of Lading and in the Charter Party. In the Bill of Lading, all exceptions, terms and conditions of the Charter Party are incorporated, and there's no issue between the parties as to which Charter Party we're talking about. As to the Charter Party clause, just remind the court of it, it's at page 323 of the core volume. And it's clause 13.10 of the bill of the Charter Party. This Charter Party shall have effect subject to the Hague-Visby rules, which shall apply to any bill of lading issued under this Charter Party. So the wording is shall apply to, which is in our submission different from be incorporated in. And in our submission, the approach taken by the arbitrators, and this is an area where the experience of the arbitrators is relevant, is in our submission compelling.
I don't see how you can extend the scope of what the Hague rules mean by applying them to a contract.
Well, it depends what you mean by applying them to the contract. Are you saying I'm incorporating the Hague rules as they are into the contract, or am I saying, or is one saying I'm applying the Hague rules as they stand to the whole of the contract?
But the Hague rules as they stand, and they have the scope that they have, which we've just been discussing. They don't magically enlarge their scope because you choose to apply them to something, whether you call that incorporating or applying or whatever you call it.
Well, we would submit that when the parties use the words applying, I wouldn't say they're magically extending it.
Now that might be slightly pejorative, but
a bit high. But their objective intention is to apply the Hague rules or Hague-Visby rules to the whole of the contractual relationship under the bill. That's our submission. And can I show you how the arbitrators dealt with it? Because in our submission, how the arbitrators dealt with it is persuasive. It's in the award. Which is in the e-documents bundle. Starting at page 209. It starts at paragraph 109. Thank you. Importantly, they're distinguishing the MSc Amsterdam. It did not concern a bill of lading incorporating a charter party, providing that, and then the apply words. Here we are concerned with the contractual application of the Hague-Visby rules to any bill of lading issued under this charter party, and the true construction of that term. The bill of lading in terms applied the Hague-Visby rules in effect to this bill of lading, and the question is what that means. Does it mean, in the more confined sense, the specific limited carriage by sea aspects of this contract contained in or evidenced by this bill of lading, or does it mean more generally the parties' rights and liabilities under this bill of lading and the contract contained in or evidenced by it? It is our view that the proper construction is the more general one, and not the one confined to the specific carriage by sea aspects. After all, delivery as against the presentation of the bill of lading is well known as fundamental, and it would be somewhat bizarre to exclude such a fundamental provision from general words. The present bill of lading is thus in important respects radically different from the terms of the bill of lading in the MSc Amsterdam. It seems to us that what we may call the Carver implication is entirely apt in the present case and is not excluded, if indeed any application is required at all, given what we say in paragraphs 101 and 102 above. Contractually and indeed compulsorily, because they applied, shall apply to this bill of lading also in relation to ascertaining which set of rules applied, Hague or Hague-Visby, and that's what they do earlier on in the award. Contractually and indeed compulsorily, the Hague-Visby rules apply to the bill of lading and thus to the whole matrix of rights and liabilities under the bill of lading, which must by definition persist up to the giving of right and true delivery. And that's our case essentially in a nutshell. We say that was right.
But effectively, they're not applying the Hague rules. They're changing. They're applying some of the Hague rules, but not the entirety, as it were, because the Hague rules, as you've accepted, have a certain period of scope.
For certain things, yes.
And that's what you're applying. I mean, but the effect of this is to say, in fact, you're extending that scope.
Yes, precisely. Because why are they saying we're applying it to the bill of lading? I mean, in our submission, there would be a difference if it said we incorporate the Hague-Visby rules in the bill of lading, because there you're just writing them out in the bill of lading. But here you're saying you take the set of the Hague rules and you apply it to the entire bill of lading. I mean, the point is as short as that.
Okay.
I mean, the basis for this part of the argument is that the claimants have a full Limitation Act period available to them of 6 years.
Yes.
But you say that's being cut down by this contractual term. So would you accept that the usual principles that if you're giving up important rights, that needs to be clearly expressed in the contract apply, so that we have to apply a test of clear expression of intention to cut down those usual rights?
I would, my lord. But I would say that this was...
You say it is clear, of course, you have to.
It's sufficiently clear. But when one's considering the common practice of extending the application of the rules, for example, in the charter party context, in other bill of lading contexts, in our submission, the wording is apt to satisfy that test. All it is saying is that the Hague rules on their own apply to a certain part of this contract. We're going to apply them to all of it.
But it's the whole package, it's not just
It's the whole package.
exemptions.
Yep, it's the whole package. Yep. So, my lord, that's all I wanted to say about the express application. In terms of the implied application, the tribunal were prepared to find that it would be an implied term of the bill of lading, absent any express claim to the contrary, or absent any provision carving bits out, that the Hague-Visby rules would apply by an implied term.
How does that work on the standard implied term test?
And Lord, the point again is a very short one. We submit that it is a term which goes without saying, because when you ask a carrier and a cargo owner who've got a single bill of lading, which covers a sea carriage with a loading bit at the front and a discharge and delivery bit at the end, where the parties have not, or to the extent that they have not made express provision for the ends, as it were, if I can put it in an elegant way, they are likely to assume and likely to wish that the result is the same throughout, because it avoids split regimes, it avoids fine distinctions, it means that there's a time bar which is common throughout the whole contract of carriage, rather than split off and depending upon when loading ends and when discharge begins. In our submission, it's what one would expect parties to agree. And we have support for that in the decision of the MSC Amsterdam, where an experienced Court of Appeal said that it might be very easy to suppose that, absent express provision to the contrary, the parties would have intended the rules to apply. And we submit it's a question really as to whether that intuitive feeling that this is what goes without saying, whether that intuitive feeling is right or not. And we submit that both the textbooks that have considered it have lent in favour of it, but those words of Lord Justice Longmore in the MSC Amsterdam, which perhaps I just should take the court to, which is at page 972 of the core volume. Oops. Sorry, my lord. Page, sorry, my lord, I do apologise. 1422. I've got the wrong volume.
It's the right page.
The right page of the wrong volume.
Paragraph 23.
That's the perils of working off paper, my lord.
Yes.
Court will have read it by the time I get there, I think.
Yeah.
Yes, it's paragraph 23. It must follow from this that the parties are free to agree on terms other than the Hague Rules for periods outside the actual period of the carriage. No doubt if no agreement is made for the period after discharge, it might be easy to say, and those words are, in my submission, important, that the parties have impliedly agreed that the obligations and immunities contained in the Hague Rules continue after actual discharge until the goods are taken into custody of the receiver. That is a view expressed in Carver on bills of lading.
But if the proper interpretation of Rule 6 is it extinguishes only liabilities that relate to the carriage period, it's a pretty strong thing to imply into the contract an extinction of later liabilities when there's nothing to suggest other than applying the Hague-Visby rules that that's intended. And applying them doesn't have that implication because that brings with it the meaning of those rules as they're properly interpreted.
Well, it depends what the implication is. If the implication is we agree, impliedly, that the rights and immunities of the Hague Rules, which apply between these two periods, apply generally. That's what the implication is. So it is just like, I won't say the magical extension with to apply, but it is an extension. I accept it's an extension. It has to be an extension because the whole of this second issue depends upon my being wrong.
Yeah, exactly. Yeah.
So we have the Hague-Visby rules and the time bar strictly delimited by loading and discharge. So here we have either an express agreement or an implied agreement to extend.
I see.
I don't really understand how this implied term agreement gets off the ground in the light of clause 13.10 in the Charter Party. So we've got an express clause applying the Hague-Visby rules, which has the meaning which it has. We've discussed that earlier. So what possible room is there for an implied term doing not quite the same thing?
My lord, I take that point, and which is why the arbitrator's approach was really to focus on 1310.
Well, I mean, they must be right, mustn't they?
And also to say that it's an express application, but it also supports the parties were directing their minds to the general application. But I quite take.
I see. So what you're really doing is bringing in aid of your in your interpretation of 1310 the thinking that lies behind whatever it is that Carver and Sir Gunter Treitel have said.
Yes.
In this context.
Your Lordship is right. You might put it round as it were the other way. Absent an express term, there would be an implied term.
Yeah.
See Carver. That expectation supports
your construction of
our construction
1310.
of 1310
I see.
and buttresses it.
Yes, I see.
I'm grateful, my Lord. My Lord, unless I can help the Court further on issue 2.
Does clause 2C affect this?
My learned friend Mr. Chan is going to address the Court on the true meaning of clause 2C. Right. And that's why I've been careful to say that to the extent that the parties haven't contracted out of the rules, or either altogether or contracted out of certain of the rules, and that brings one on, as it were, neatly to clause 2C, where the issue is, what is the effect of clause 2C? And if the rules apply, then I'm right on issue 1, either on the Hague rules or the Hague-Visby rules or both. What is the effect of clause 2C on the Hague rules applying? But it also, your Lordship is quite right, has relevance to what has been carved out from the application of the Hague rules by 1310 or by the implied term understood in the way in which I've reformulated it. Lord Richard's question. So unless I can help the Court further on those two issues.
Thank you very much. Mr. Chan.
May it please the Court, I will be addressing your Lordships on issue 2 of the appeal. And this issue arises if we are right on issue 1, and the Article 3, Rule 6 time bar does apply after discharge and up to the point of delivery. And in particular, if the time bar does apply in respect of claims for missed delivery after discharge. The question for the Court on that premise is whether the parties have nevertheless agreed, by way of Clause 2C of the Congen Bill, to disapply the Hague-Visby rules, including the time bar, in relation to the period after discharge. And in short, my Lords, we say that that is unsustainable as a matter of construction and unsupported by the MSc Amsterdam, which concerned a very different set of clauses and does not assist in an interpretation of Clause 2C, as the Tribunal found and as the courts below found. May I first take your Lordships again to the text of Clause 2C, and that is in the core volume at page 340. The Clause 2C, your Lordships have seen this a number of times. The clause reads that the carrier shall in no case be responsible for loss of or damage to the cargo, howsoever arising prior to loading into and after discharge from the vessel, or while the cargo is in the charge of another carrier, nor in respect of deck cargo or live animals. And the appellant's case in substance, my Lords, seems to be that although Clause 2C, they accept, makes no express reference in terms to ousting the time bar or the rules as a whole, the party's intention to exclude the carrier's responsibility after discharge implicitly indicates an intention to contract out of the entire set of rules, which the appellant says is permitted by Article 7. And it is important, my Lords, to note first the premise on which this argument is advanced, which the Court of Appeal acknowledged in their judgments, and this is page 130 of the key documents hard copy bundle at paragraph 89. Paragraph 89, my Lords. The Court of Appeal said, Mr. Smith submits that this clause is effective to disapply Article 3, Rule 6. However, this issue arises on a somewhat artificial basis because we are not asked to decide, and it is not a question of law arising out of the award whether Clause 2C is effective to exclude liability for misdelivery after discharge altogether, regardless of any time-bar defense. Although the judge did say that it is well established that such words in the bill of lading are insufficiently clear to relieve the carrier from liability for misdelivery. If Clause 2C does exclude such liability, the issue of time bar will not arise. Paragraph 90, the court concluded that, on the other hand, if the carrier does remain liable for misdelivery after discharge, despite Clause 2C, which we must assume to be the case as the point is otherwise irrelevant, there is no reason why the one-year time limit should not apply. So the court, as Lord Justice Males found, is not being asked on this appeal to decide the question of whether Clause 2C does effectively exclude liability from misdelivery altogether. But in line with the Court's reasoning, it is either the case that Clause 2C effectively excludes all such liability, or it does not. And if it is effective to exclude all liabilities, because Clause 2C provides for a complete and self-contained contractual code that regulates parties' relations after discharge, then the issue of time bar does not arise. And this was the point that my Lord Legate made yesterday. And the time bar issue, therefore, only ever arises on the premise that the parties did not intend by Clause 2C to exclude all liabilities, and that for present purposes, the carrier remains potentially liable for misdelivery after discharge. So the question for the courts, my lords, is whether in those circumstances the parties have intended by Clause 2C, by the words you see in the court volume at page 340, to exclude the operation of the valuable time bar rights which would otherwise be available to the carrier under Article 3, Rule 6 in relation to post-discharge liabilities. And on that premise, and in any event, we submit that the wording of Clause 2C simply is inconsistent and incompatible with any intention by the parties to disapply the time bar. And there are 3 points that I wish to make in this respect in relation to the language of the clause. First, the provision only expressly relates to and purports only to delimit and to demarcate the carrier's responsibility or its liability in relation to loss of or damage to the cargo. Clause 2C does not expressly mention the Hague rules in terms or the Hague-Visby rules in terms, still less does it purport to exclude those rules as a whole. And in this respect, Clause 2C differs to Clauses 2A and 2B, where the drafters have spelled out in terms that the Hague rules or the Hague-Visby rules shall apply to this bill of lading. And the clause also does not specifically address the time bar in Article 3, Rule 6, which does not impose a responsibility or a liability on the carrier. The second point is that the language of Clause 2C materially reflects the terms of the Hague-Visby rules themselves. So Clause 2C refers firstly to the carrier having no responsibility before loading or after discharge, but that, as your lordships will note, substantially mirrors the provisions of Articles 1E and 2 of the rules, which provide for a period of responsibility between loading and discharge, and which my learned senior has already addressed in relation to Issue 1. And a similar point may be made about the references in Clause 2C to deck, cargo, and live animals, which precisely reflect the two carve-outs to the definition of goods that appear in Article 1C of the Hague Rules and the Hague-Visby Rules. And for the Court's reference, those provisions are at pages 995 and 1007 of the core volume, though I do not propose to take the Court there. The basis on which this issue is to be decided, as I submitted earlier, is that the time bar does apply after discharge on a proper construction of the Hague-Visby rules when read as a whole. And on that basis, we respectfully submit that there is simply no reason to find that the parties somehow intended to oust either the entirety of the rules or the time bar specifically, simply because they have done nothing more than to adopt, in substance, some of the language and some of the concepts that already appear in the rules themselves. And thirdly, my lords, the clear intention underlying Clause 2C in our submission is to protect the carrier by providing or clarifying that the carrier is not responsible in a number of situations, including in relation to the period after discharge. And that is, we say, inconsistent with the appellant's contended interpretation, which would give rise to responsibility in a case where no responsibility would otherwise arise, because it would deprive the carrier of a valuable time bar defense that would otherwise be available. And for these reasons, Sir William Blair observed in his judgment at paragraph 89, and this is page 174 of the key documents bundle, that the result for which the appellant argues would be a counterintuitive one.
What you're saying is it would be perverse if a clause intended to reduce the carrier's liability had the effect of increasing it.
Exactly, my lord. And this was precisely one of the reasons, not the only reason, but one reason that Sir William Blair thought was significant in ruling as he did.
Yes, so you would say it's belt and braces. You can have both.
Yes.
If for some reason this clause is construed narrowly, you can fall back on the time bar.
Yes,
Yeah.
exactly.
And there does appear to be a Court of Appeal authority construing it narrowly, is that right? Although we haven't been taken to it, but it's mentioned by the Court of Appeal, a case called Motis Exports.
Yes, my lord. And the point raised by Motis, which is in the core volume, is that that was a decision about an exclusion clause that purported to exclude liability by the carrier in relation to loss of or damage to the goods.
Exactly like this clause, I think.
Similar, my lord.
Oh, yep.
And the issue in that case was whether such clauses were apt to exclude liability for misdelivery altogether. And as the Court of Appeal noted, it's the starting points must be a binary one. Either Clause 2C is effective to exclude liability for misdelivery, in which case we don't even get here because we are exempt from liability, or the parties have intended not to exclude liability for misdelivery, in which case the time bar is relevant, but also in that case, there remain post-discharge liabilities, such as that for misdelivery, to which the time bar actually has a use and can valuably be relied on by the carrier. In those circumstances, my lord, the question we say the court has to decide is whether in those circumstances, where there is a useful time bar right, the parties have intended in the very sparse wording of Clause 2C to exclude the time bar. And we say that there simply isn't that intention in this wording. So those are the reasons that in our submission, just as a matter of language of Clause 2C and looking at it in isolation, there is simply no sensible basis on which the court could read into the language of Clause 2C any intention to exclude either the entirety of the rules, which is encompassed in the appellant's case, or the time bar specifically in respect of the period after discharge. And this is all the more so, as I've just said to your lordships, if the carrier remains liable to claims for misdelivery, to which such a time bar can usefully be applied. And what the appellant has to show the courts on this issue is that although Clause 2C purports only to exclude liabilities, and to do so without any qualification, it in fact is not sufficiently clear to exclude liability for misdelivery, but somehow is sufficiently clear to exclude the entirety of the Hague-Visby rules and the time bar, to which no reference is made in the clause at all. And in our submission, that is not a workable reading of the clause. And the appellant's case, we submit, is not assisted or improved by the reasoning of the Court of Appeal in the MSC Amsterdam, which was a very different case about a fundamentally different bill of lading, as the tribunal and the courts below found. And this was a case about the MSC House bill of lading, and your lordships have already been taken to that case on a number of occasions, but the relevant provisions for these purposes are at pages 972 and 973 of the core volume. And may I please invite your lordships to take a moment to read these clauses again to yourselves.
This is at the bottom of 972.
Yes, sorry, my lord. This is the bottom of page 972.
Yes,
it appears in paragraph 24 of Lord Justice Longmore's decision.
We've seen these, yes.
Yes. So the relevant clauses are clauses 4.2, 4.3, and 7. My lords, the appellant's case is that Clause 7 adds nothing in effect or nothing material to Clause 4.2, which it says mirrors the wording of Clause 2C. In our submission, however, Clause 7 is significant in two respects. Firstly, it provides that discharge onto key or into shed, warehouse, depot, vehicle, vessel, or craft shall constitute due delivery of the goods under the bill of lading. And secondly, it provides at the end of the excerpt that any loss of or damage to the goods shall, after the end of the Hague Rules period, be at the sole risk of the consignee in every respect whatsoever. And Lord Justice Longmore cited all three clauses and then stated that these clauses make it clear to my mind that the parties did not intend the Hague Rules to apply after discharge from the vessel. The fact that Clause 7 refers to loss after the end of the Hague Rules period shows that there is to be a period when the Hague Rules do not apply, but which will otherwise be a time when the owners may still have the obligations of a bailee in respect of the goods and can agree that the terms of that bailment are not to be those of the Hague Rules. The owner's purported disclaimer of liability for what happens after discharge does not make any difference to that intention. And at paragraph 26, my lords, Lord Justice Longmore said that he agreed with the judge, Mr. Justice Aikens. And if I may refer your lordships to Mr. Justice Aikens' judgments, which starts at page 924 of the core volume.
Sorry, page?
Page 924.
924, thank you.
The relevant passage for our purposes starts at page 947. And it starts at paragraph 94 of his lordship's judgment. So at paragraph 94, Mr. Justice Aikens stated, the Hague Vistry Rules, rights and obligations are concerned with the carriage of goods by sea. I accept that this phrase must include activities both before loading on board and after discharge from the sea-carrying vessel, but it is clearly established that it is up to the parties to define the temporal scope of the rights and obligations, in particular whether they apply after discharge. That is the effect of Article 7. In this case, the general approach of the Bill of Lading terms, but in particular those of clauses 4, 2, and 3, is to limit the responsibilities of the carrier to the time when the goods are on board. Clause 7 emphasizes that due delivery of the goods takes place by discharge onto the quay or into a shed, warehouse, depot, or other premises. At paragraph 95, it is implicit not only in this wording, but also in particular the sentence of Clause 7 that states any loss of or damage to the goods shall, after the end of the Hague Rules period, be at the sole risk of the consignee in every respect whatsoever. That there will be an end to the Hague Rules or the Hague Vistry Rules period before the consignee has taken custody of the goods, but rather at some earlier period. In my view, the phrase after the end of the Hague Rules period is referring to the moment after the goods have been discharged. That is what the parties have apparently agreed as the delivery of the goods, as is clear from the wording of Clause 22. And my lords, just for your lordship's reference, the relevant parts of Clause 22 is reproduced at paragraph 91 of the bundle at page 946 of the core volume.
Paragraph 91 of the judgment.
Of the judgment, my lord, yes. So as you can see, it refers back to the date of delivery as defined in Clause 7. So, my lords, Lord Justice Longmore and Mr. Justice Aikens both regarded it as significant, the fact that Clause 7 refers in terms to a Hague Rules period, because it necessarily followed from that there was to be a period after that when the Hague Rules as a whole will not apply. And that period, as they both found, was the period after discharge, as indicated not only by Clause 4.2, which the appellants say mirrors Clause 2c, but also Clause 4.3, which refer, and also the provision in Clause 7 that discharge in accordance with that term will constitute due delivery. So in our submission, the MSC Amsterdam does not assist this court when it comes to interpreting Clause 2c. Clause 2c contains no reference to a Hague Rules period or a Hague Vistry Rules period and does not provide that discharge is to constitute due delivery. And unlike with the MSC bill, we submit that there is no indication or suggestion in the language of the clause that the parties intended to disapply the rules after discharge. And if I may refer your lordships to the tribunal's award on this point, and this is page 208 of the hard copy key documents bundle. Tab 9. My lords, at paragraph 107, and this is in the middle of a discussion of the MSc Amsterdam generally, but paragraph 107 addressed the point about whether the rules apply to events post-discharge. If your lordships turn the page to page 209, in the second half of paragraph 107, the tribunal specifically discusses the Carver implied term, and then they say, in fact, no such implication was possible in the MSc Amsterdam, given the express terms of the MSc Bill of Lading, Clause 7, of which made very specific provision for responsibility for loss of or damage to the goods after the end of the Hague Rules period to lie with the consignee. And since Clause 7 also provided that discharge was to constitute due delivery, the tribunal thought that it was easy to see why Lord Justice Longmore regarded the clause as a clear indication that the parties to the Bill of Lading had agreed to a specific period of application of the Hague Rules, ending with discharge. And my lords, on the next page, if I could refer your lordships to paragraph 115. The tribunal has returned here to consider specifically the Clause 2C point that the appellant now raises. And in the last sentence of paragraph 115, the tribunal thought that they did not think that the effect of the quoted term is anything like the detailed and temporally specific provisions of the MSc Bill, which moreover embodied an express contractual agreement as to when delivery should take place, and thus also as to when the period of Hague Rules responsibility should end. My lords, if I could then refer your lordships to what Sir William Blair said on the point, was to materially similar effect, and that is page 174 of the hard copy. So paragraph 91 of Sir William Blair's judgment, he said that I have concluded in agreement with the tribunal that the MSc Amsterdam is distinguishable. And if we go to page 176, he sets out some of the reasons why he reached that conclusion. So at subparagraph 3, Sir William Blair said that Clause 7 is set out in full in Mr. Justice Aiken's judgment, and it is lengthy. Fimbank submits that the operative provision in both bills for present purposes is the exclusion of all responsibility after discharge. But as KCH submits, the MSc Bill made very specific provision for responsibility after the end of the Hague Rules period, and expressly provided that discharge shall constitute due delivery. So your lordships have the point. It's essentially accepting the tribunal's distinction between the MSc Bill and Clause 2C. And at subparagraph 5, finally, Sir William Blair also says that Clause 2C contains no reference to any Hague Visby Rules period. Whatever the parties might have intended in relation to the liability of the carrier after discharge, they have said nothing about the carrier's ability to rely on its immunity under Article 3, Rule 6, or about the Hague Visby Rules generally. And we submit that the tribunal and Sir William Blair were plainly correct for those reasons. And, my lords, ultimately the issue for the court is whether the wording of this specific clause is sufficiently clear to oust the time bar or the rules. And this needs to be considered on the assumption that this wording is not sufficiently clear to exclude liability for misdelivery, such that there are potential post-discharge liabilities to which the time bar can apply. We submit that the language of Clause 2C does not come close to ousting the rules of the time bar after discharge. And unless I can assist the court further, those are our submissions on issue 2.
Mr. Chairman, thank you very much.
Thank you.
Smith.
My Lords, I shall take the points in the same order that they arose earlier, with one exception, which is this. The first point that arises on either of our cases is the proper construction of the Hague Rules. And my learned friend started, for obvious forensic reasons, by going straight to Article 3, Rule 6, rather than looking at it in the context of the rules as a whole. I invited the court to start by looking at the rules as a whole and then look at Article 3, Rule 6 in that context. But for the purposes of my reply, I'm going to take the points in my learned friend's order and look at Article 3, Rule 6 first. And the reason for that is that we would accept that if you were looking at Article 3, Rule 6 in isolation, as a standalone clause that had been inserted into a bill of lading, as Clause 17 in the New York Star, then the wording viewed in isolation is wide and is apt to exclude or apply the limitation period to all claims whenever arising. But the reason for that is important. The reason is that you would be simply looking at that clause as a standalone clause in the bill of lading, rather than as part of a package in an international convention representing a compromise between the interests of the owning community on the one side and the cargo community on the other side. And so, in our submission, the court can and should put to one side considerations of what Article 3, Rule 6 would look like viewed in isolation, and instead, as we did yesterday, to look at it in the context of the Hague Rules. And in that respect, it is important to note, as I've said, that if Article 3, Rule 6 was there in a bill of lading, it would apply to the whole of the bill of lading contract because the parties had chosen it. Whereas in the context of the Hague Rules, Article 3, Rule 6 is applicable because we say Article 2 says it is. And in that respect, can I ask the court to turn up Plyrene and Cyndia again at page 415 in the core bundle.
The page number?
415, my Lord.
Thank you.
Sorry, no, that's the wrong reference. 823. Apologise. And in just below halfway down, the paragraph begins, Article 2. And Mr. Justice Devlin says there, Article 2 is the crucial article which for this purpose has to be construed. It is the article that gives the carrier all his rights and immunities, including the right to limit his liability. And that, we submit, is the correct approach to the rules, that Article 2 is the gateway.
I think, though, isn't he there when he refers to the right to limit his liability, he's talking about the package limitation?
He is, my Lord, and I'm going to come on to address the issue of whether time limitation comes within the same category. That's the issue about liabilities, responsibilities, rights and immunities. I'll come on to that. But the starting point in our submission is that Article 2 is the gateway to the provisions of Articles 3 and 4. And the provisions of the Convention apply to bills of lading because Article 10 of the Convention says they do. And as I've said, the first operative provision of the rules is Article 2. And Article 2, as we saw yesterday, adopts the terms defined in Article 1. And if we could then take up the rules again at 1233, what Article 2 says is that subject to the provisions of Article 6, which is the provision allowing special terms in relation to some particular cargo which we're not concerned with, under every contract of carriage of goods by sea, so that's the defined term, the carrier, in relation to the loading, unloading, handling, stowage, carriage, custody, care and discharge of the goods, shall be subject to, and these are the important words, the responsibilities and liabilities and entitled to the rights and immunities hereinafter set forth. And in our submission, in context, that wording describes the provisions set out in Articles 3 and 4, and that means all of the provisions set out in Article 3 and 4. So it is a package, or as referred to in some places in the Travo, a code of responsibilities, liabilities, rights and immunities, which, because of Article 3, Rule 8, applies compulsorily to the carriage by sea, but by virtue of the definitions, only to the carriage of goods by sea. And in that respect, there was the debate yesterday about whether Article 3, Rule 6 was a responsibility, a liability, or right, or an immunity. Our case remains that it should be dealt with under the heading liability. And the reason is that although it doesn't create a liability, it discharges liabilities.
Well, that's why it's a right, isn't it?
Well, my Lord, I was going
the liability is imposed by Rule 8.
Well, my Lord, in one sense, Rule 8 is slightly different. What that says is one can't contract out of the liability.
All right. Well, that's what puts the. You can't lessen that.
My Lord, yes. Our point is rather wider than this. There's actually nothing in Article 3 that says you are liable for. What it does is create some responsibilities, and you are then liable for breaching those responsibilities unless that liability is discharged. And so, consistently with the headings which the draft person of the Hague Rules, sorry, the 1924 Act inserted, and as my learned friend said this morning, were used during the debates in the Travo, if not actually in the Hague Rules. Consistently with those headings, Article 3 comes under the heading responsibilities and liabilities. So it is our submission, I don't shirk from it because I made it yesterday, that it should be treated under the heading rights, responsibilities and liabilities.
Well, it doesn't impose any liability, does it? It removes liability after a certain period.
Discharges from it.
It discharges it, extinguishes it.
So what we would say is it defines the carrier's liabilities. It defines when those liabilities come to an end. But it may not matter, because in our submission, if I'm wrong on that, nonetheless, Article 3, Rule 6 is clearly, and must be, a right or immunity, because it is the right to be discharged from liability after a certain period of time. And in one sense, in our submission, this debate doesn't matter, because so long as Article 6 comes within the ambit of the phrase responsibilities and liabilities, rights and immunities hereinafter set forth, Article 2 is the gateway to Article 3, Rule 6, as Mr. Justice Devlin said, albeit in the context of package limitation, Pyrene and Cindia.
But what seems to me important is that Rule 6 goes beyond the Hague Rules obligations and applies to contractual and tortious obligations as well. I think you accept that.
As a matter of English law, it has been held to do so, and because of the amendments made under Visby, it most certainly does so, to claims in tort as well.
So what do you say about a case where delivery takes place a little after discharge, and then but the goods are short-delivered or they're delivered in damaged condition? There's then a contractual claim, isn't there, for a breach of contract for not delivering the goods in accordance with the contract. Do you say the claimant can pop up 5 years later and say, I'm bringing my contractual claim and it wasn't extinguished because Rule 6 cuts off at discharge, and these goods were delivered 2 weeks after discharge.
My Lord, yes, I do say that, just as much as the carrier could insert into his bill of lading a time bar that said, I will be discharged from liability after 40 days.
Well, that's a pretty unattractive consequence. It means in almost every case, well, in any case where there's delivery after discharge, the Hague Rules time limit won't apply to the contract claim.
Well, my Lord, no, with respect, for this reason. My Lord has said where there's delivery after discharge, we're talking about if there is misdelivery. So if there is...
Well, we are here, but I'm posing just the common or garden case, or for short delivery or damaged goods being delivered after discharge.
My Lord, damage to goods, where the damage occurs during the period of responsibility, will still be, and I'll come back to the period of responsibility, will still be caught by the 1-year time bar, because the claim there, although the receiver only makes the claim after delivery because he only receives the damaged goods after delivery, is alleging, albeit he can describe it as a claim in tort or a claim in some other contractual terms, is nonetheless bringing a claim that falls within the period of responsibility.
Yes, but if the claim is made 5 years later, there'll then, on your case, have to be an argument about whether the damage occurred during the voyage or on the quay. And on that will depend whether the claim is time-barred or not. And so the carrier won't have been able to close their books, because even though the goods no claim was made within a year, that won't stop the argument being made later.
My Lord, I accept that, and I think I said yesterday, if it was a case of damage on the quay, I accept that it is a consequence of our submission that the Hague or Hague Visby Rules time bar does not apply to bar that claim. Yeah. But equally, the Hague and Hague Visby Rules, Article 3, Rule 6, does not prevent the carrier from contracting for a shorter limitation period. So,
well, I mean, the claimant will simply say, I received the goods in damaged condition. It's up to you, carrier, to say how and they got damaged. Then the carrier will find themselves 5 years down the track having to establish where the damage occurred. They'll be trying to argue probably that it occurred on the ship, because then there'll be the claim will be time barred.
My Lord, I can't escape from that being the consequence of my argument.
No.
But equally the consequence of my argument is that if the carrier had put into his house bill of lading or whatever a shorter time limit covering the period after discharge, then he can close his books. And that's why it's important to go back to the Hague Rules times and bear in mind that Article 3, Rule 6 was seen as a victory for the cargo interests. It's easy now because it's the carrier that's wishing to rely on the 1 year time period and relying on it as a provision that benefits the carrier, to lose sight of the fact that originally extending the time period that carriers usually insisted on to 1 year was a win for the cargo interests.
Just pursuing the point about the fine distinctions that your argument seems to lead to, I mean, wouldn't it also lead to arguments, quite subtle arguments, about the nature of the obligation that has been breached? I mean, usually, if there's a misdelivery, the breach of obligation is that the goods have not been delivered in proper order. And that in itself is a breach of obligation. You don't necessarily have to say, and what's more, the reason they weren't delivered in proper order was because they were damaged on the ship or on the quay. So your argument seems to depend upon drawing quite subtle distinctions between the nature of the obligations as well as potentially in relation to the timing, doesn't it?
My Lord, in our submission, not, because if the damage has occurred on board, I shouldn't say on board, during the period of responsibility, I'll use that phrase if I may, but I do need to come on to make some submissions about it, during the period of responsibility, then the carrier, by not delivering the goods in the like good order and condition as they were evidenced by the bill of lading, is prima facie in breach of the contract of carriage, unless he can bring himself within one of the exceptions set out in the rules that apply to that period. or those operations. On the other hand, if the carrier were to say, and he would then bear the burden of proof, that, for example, take a cargo of steel coils or something that's been discharged and then suffered rust damage whilst ashore, the carrier would bear the burden of saying the damage occurred during the storage ashore after the period of responsibility. And in one sense, he then loses the benefit of the Hague Rules or Hague-Visby Rules exceptions in Article 4 if he wanted to avail himself of one, if one applied, but he has the benefit of then arguing for a shorter limitation period if he's contracted for one. But, my Lord, can I deal with head-on the difficult points and distinction point that my learned friends make? And the answer to it in our submission is this, that it's always going to arise, even on their case, because of the operation of Article 7. And because Article 7 creates complete freedom of contract, again, if I may use the shorthand, outside the period of responsibility, there is always the possibility of having to investigate, did this loss occur outside the period of responsibility or within the period of responsibility? And that's built into the rules. And therefore, that's why I don't shirk from saying that that is a point that might have to be considered by an arbitrator or a court in due course. It's a point that had to be considered in Pyrene and Scindia, because there the argument was that the old-fashioned, if I can put it that way, English approach, tackle to tackle, governed. Mr. Justice Devlin said, no, it's wider than that. We're looking at the whole operation of loading. Likewise, one would look at the whole operation of discharge. Similar exercise had to be undertaken by the Court of Appeal in the OT Sonia, where they had to look at whether the loss claimed in the smaller loss, the second claim, arose during part of the loading operation, and they held that it did, because the cause of the loss was delay in loading. And so they had to take what might call it, a wide approach to what was encompassed within loading. So delay in loading was part of the loading operation. Same in the Sophie J, where Mr. Justice Tomlinson was influenced by the fact not only that loading had in fact started when the unseaworthiness of the barge was discovered, but that the unseaworthiness of the barge caused further delay in the loading, and the expense was that the loading operation was more expensive. So in fact-specific cases, a court is nearly always going to have to look at the issue of whether this is within or without the period of responsibility. Period of responsibility. But that is a distinction that is built into the rules because of Article 7, and because the compromise made at The Hague involved essentially saying the owners are prepared, the owning lobby is prepared to give up their freedom of contract, but only in relation to a precisely defined period. And my learned friend took my lords this morning to the arbitrators' reasons, where they referred, I think the phrase they used was whether there was any objective reason. I'll just find my note. Where did you put my volume on? If I could have a moment just to find the reference, because I've just taken this out of turn slightly.
Was it the paragraphs on page 213, paragraphs 125 to 7?
Yes, 126 and 127, where they said there was no obvious analytical reason why that approach would be appropriate. I'm sorry, my lords. I'm looking at the core bundle at page 300. My learned friends, I think, took it to you in the key documents bundle, but it's paragraph 126 and then 127, where they say there's no sound objective reason. And with respect, that overlooks the fundamental point that the sound objective reason for our approach is that it faithfully follows the compromise, the bargain made as part of the Hague Rules. That if the owners give up their freedom of contract, they only give it up within a tightly prescribed period. And so in our submission, it is a question of looking at Article 2, which is the gateway that brings in the whole of Article 3 and the whole of Article 4, Article 7, which then gives complete freedom of contract. And that is why, in relation to, quotes, custody, care and handling of the cargo after discharge, the carrier can contract for a shorter limitation period, if so advised. And with respect, I see the difficulties that can arise as a result of my arguments in some contexts. But the key difficulty that arises, or one of the key difficulties that arises on my learned friend's construction, is the difficulty he has with the interrelationship between Article 3, Rule 8 and Article 7. And my lords will recall that yesterday when my Lord Legate put my learned friend, well, is the carrier in those circumstances entitled to contract for a shorter period of limitation after discharge? His initial answer was no. And then when he was asked later about it, I think my Lord Sales asked him to confirm that, and he did. And then when he was asked later about it by my Lord Richards, his answer was yes. And this morning his answer was unequivocally yes. The difficulty is, if Article 3, Rule 6 forms part of the irreducible minimum, it forms part of that irreducible minimum because it is one of the rights, immunities, responsibilities, or liabilities hereinafter put out in Article 2. That's why it's caught by Article 8. And one can then take into account Article 7. And to answer a question my Lord Legate posed, whether the carrier could then surrender those rights, my learned, under Article 5, my learned friend, in a sense, rather nimbly dodged that question, if I can put it that way. He said that he didn't need to, because of course you could give up those rights. But that was for the obvious reason he didn't want to say, yes, he can, under Article 5. Because Article 5 says the carrier shall be at liberty to surrender in whole or part all of his rights and immunities, or to increase his responsibilities and liabilities. So that it's the same phraseology, albeit in reverse order, as we see in Article 2. But what one has in our submission when one looks at the rules is a package that, when one looks at it as a whole, as we invite the court to, actually fits together. It has some consequences, I accept, as my Lord Legate has pointed out, in certain circumstances. But as a package, it faithfully reflects the discussions that took place that we looked at yesterday in the Travo for the rules. And if my lords still have Pyrene and Cyndia, our approach allows all of the provisions of the rules, Article 2, Article 3, including Article 3, Rule 6, Article 3, Rule 8, and Article 7, to be read and given meaning. Can I deal with, I said I'd come back to, the use of the phrase irreducible the use of the phrase period of responsibility, and ask my lords again to have a look at Pyrene and Cyndia.
Page 823, I think, is...
I'm grateful, my lord. As always happens in a reply submissions, jumping around a little bit from one point to another, but trying to put them in order. And refer my lords again to the passage that my learned friend went to yesterday at page 824, where Mr. Justice Devlin refers to Article 1E and says, for as I've said, though not dominant, it is not irrelevant in construing loading in Article 2. Then if one reads on, about halfway down the page, the obligation in Article 3, Rule 1, for example, to use due diligence to make the ship seaworthy, man and equip her properly, are independent of time. The operation of the rules is determined by the limits of the contract of carriage by sea and not by any limits of time. The function of Article 1E, I think, is only to assist in the definition of contract of carriage. As I already pointed out, there is excluded from that definition any part of the larger contract which relates to, for example, inland transport. It's natural to divide such a contract into periods, a period of inland transport followed by perhaps a period of sea transport, and then again a period of inland transport. Discharging from rail at the port of loading may fall into the first period, loading on the ship at the second. The reference to when the goods are loaded on in Article 1E is not, I think, intended to do more than identify the first operation in a series of operations that constitutes the carriage of goods, as when they are discharged denotes the last. And so, in one sense, what that is saying is that one's not looking at issues of time, one is looking at operations, as it were. And so I've adopted the shorthand period of responsibility. I think on occasions I've referred to the temporal scope of Article 3, Rule 6. But a better analysis, and certainly we don't differ from what Mr. Justice Devlin says here, the better analysis is that certain operations are covered by the rules, up to and including the conclusion of the discharge operation. And that may be a better way of putting it than referring to the period of responsibility. It's the obligations that are within the Hague Rules responsibilities. And in one sense, that also answers the question my Lord Hamlin put to me yesterday about some obligations that, as a matter of pure time, looked at purely against the clock, as it were, have to be performed before loading or after discharge. It doesn't matter. What one has to do is analyse whether they're part of the loading and carriage of goods by sea and discharging operation or fall outside of that. My Lords, moving quickly on if I can, the English cases which my learned friend dealt with, the OT Sonia and the Sophie J, as I submitted yesterday, we submit that properly understood, they say no more than the fact that the time bar applies on the facts of the particular case because the claim arose in relation to loading. And that's particularly true in relation to OT Sonia and then in relation to the Sophie J, not only in relation to loading, but after loading had started. And our approach is we submit entirely consistent with the passages in Carver and Scrutton that we looked at yesterday. For example, page 1484, one of the extracts from Scrutton, referring to responsibilities and liabilities in Article 3, Rule 6. We maintain our submission that the consensus of the international cases takes this approach. My learned friend took you to Rambler Cycles. I'm not going to go back through that case, but in our case submission it's clear that although Lord President Thomson did at page 1199 say that Article 6 can only refer to claims for breach of Article 3, which doesn't represent the position as a matter of English law, he then identified what he said was the real question, and that was a passage my learned friend read to my Lords this morning. And the real question arose because Article 3 could only apply within the ambit of the Act itself. And that wasn't Article 3, Rule 6, that was Article 3 as a whole can only apply within the ambit of the Act, because Article 3 as a whole only applies when Article 2 says it does. So the Lord President had gone almost immediately on to direct his mind to exactly the point which we say is the point before my Lords today. The true ratio of his case, of his judgment at the right-hand column of 1199, at the bottom of that column, and then going over the page, referring to Pyrene and Scindia, and then concluding at page 1201, right-hand column, is on all fours with the analysis we urge on my Lords today. That is to say that Article 2 is the gateway, and Article 3, Rule 6 only applies to operations within carriage of goods by sea. Note, can I ask my Lords just to note quickly in passing that he also said at page 46 of the report, the right-hand column, that the words "in any event" were clearly a reference back to the first paragraphs of Article 3, Rule 6. So essentially saying that the conjunctive and neutral approach contended for in the Captain Petco Voida was the correct approach. And we submit that if there were any doubt about this, and we say there isn't, the Travo make it clear beyond doubt that our submissions reflect the compromise made at the Hague Rules. I'm not going to ask my Lords if to turn them up now, but if I can just give the references. Sir Norman Hill, referring to the original 1921 Hague Rules, that's before the debates, referred to them as a bargain and an honest effort to reach a fair and equitable settlement, page 1264. But he stressed that the rules, so the rules being considered then, only control the actual sea carriage. That was a reference to all the rules, including the proposed Article 3, Rule 6. The debate in 1921 and 1922 as to how sea carriage would be defined, whether it ended at the tackle or with delivery from the ship or whatever, and I took my lords through the different wordings yesterday at 1280 to 1283, show that the delegates specifically chose to refer to discharge, not delivery, as marking the end of, or the last operation within carriage of goods by sea. And then culminating at 1284, with the chairman observing that discharge precedes delivery, and because, in fact, if I could ask my lords just to turn up 1284, because I think it summarises the position.
Which page again?
1284.
1284.
And this is the chairman at the end of the debate in relation to Article 1. Right-hand column, the chairman observed that as discharge precedes delivery, so the delegates conscious of the fact that you've got discharge, then a gap, then delivery. And as Article 3.4, which they were considering in these purposes, dealt only with the voyage on board the ship up to the time of discharge, any claim for the later damage would have to be made under general law, national legislation or special conventions, including, we would say, time bar under general law. The draft convention having nothing to do with these cases, it remained perfectly understood that in all other cases there was the presumption, in the absence of proof to the contrary, the damage occurred during carriage under the Bill of Lading. That's again a reference to Article 3, Rule 4. And so we say it's clear beyond any doubt that everybody involved in this drafting intended to limit the compromise, the restriction on the carrier's freedom of contract to the period ending with the last operation that formed part of the carriage by sea. The only other debate at the conference was then whether the period should be 1 year, 2 year, or I think the French suggestion of 1 month, not taken particularly seriously. But finally, I took my lords yesterday to the Travo in relation to Article 7, in fact then Article 6. And it's useful to note in our submission, if my lords could turn up page 1300, my learned friend was quite right this morning to say that during these debates, each debate was preceded by a heading saying what the delegates were considering. And when they were considering this point, the heading when what is now Article 7 was in fact still Article 6. We see from the left-hand side, Article 6, limitation on the application of the code. And so the heading, the working heading given to what became Article 7 was that it was a limitation on the application of the code. And over the page, when we get it, it's now Article 7.
Can you just give me the page number again? I missed
1300, my lord, right in the middle of the page.
1300, yes, okay.
The first line of italics.
Yes, I see what you mean.
And then on the next page, 1301, the wording is now Article 7, and the code is now being referred to as the rules, and it's headed limitation on the application of the rules. So whatever the admissibility of a heading, particularly a heading that is subsequently dropped, as evidence of what this provision means, it's clear in the context of the Travo that the delegates knew that what they were talking about was a limitation on the application of the rules. And that means in our submission the whole of the rules, including Article 3, Rule 6. And my lords have already the submissions I made yesterday in relation to the other debates going on in relation to Article 7. If I can move then quickly on to the Visby Protocol and the other points my learned friend has dealt with today, if we're right on Hague rules, then the time bar does not apply in relation to any claims arising after the discharge operation. My learned friends essentially say that because those who drafted the Visby Protocol intended to make it clear that the time bar did apply to misdelivery claims, and because they say most misdelivery claims occur after discharge, it follows that the drafters of the Visby Protocol intended the time bar to be extended beyond that which it presently applied to apply after discharge, and that the wide wording implements that intention. In our submission, the Travo do not support that suggestion. In particular, as I said yesterday, the delegates specifically rejected any suggestion of widening, use the phrase advisedly, the period of responsibility. They specifically rejected the suggestion of altering the scope of Article 7. My learned friend was this morning right when he took my lords through the comments made by the different maritime law associations to point out that the wide wording that we end up with in amended Article 3, Rule 6 had its roots, I think it was the Finnish delegation. Swedish delegation, when they said if we're going to expand it to cover misdelivery, it ought to cover all other indirect claims as well. So that's why a wider wording was required. So the wide wording is intended to cover misdelivery claims and other indirect claims not involving loss of or damage to the goods. If we're right, which on the posit we are, as to the Hague rules, time bar, as a result of the Hague-Visby rules, has been extended beyond the period of responsibility, not just for misdelivery, but for all claims. Because if my learned friend is right that the wide wording of Article 3, Rule 6 in the Hague-Visby rules applies outside the carriage of goods by sea, the period of responsibility, the operations defined by 1E, then it applies outside that period in all cases. To take my Lord Legate's example, a wetting damage, any other kind of damage, the time bar now applies after discharge, whereas under the Hague rules on this posit, it did not. One thing that is clear beyond doubt is that those involved in drafting the Visby Protocol only intended to alter the position in relation to misdelivery and other indirect claims. Yet if my learned friend is right, the inescapable conclusion is that they, presumably accidentally, extended the time bar to cover all claims arising after discharge because of the wording they used. And that, in our submission, is not the correct result. We submit that it's quite clear that what they had in mind was extending the time bar to cover misdelivery and other indirect claims, but no more than that. My Lords, very briefly, the last three subjects. Wording of incorporation and whether there's an express intention to apply the Hague rules, even though they don't apply after discharge, to the whole of the Bill of Lading contract, including the period after discharge. In our submission, one only has to state that proposition to see how flawed it is. If the rules within their own wording are limited to the period ending with discharge, applying the rules to the contract or making the contract subject to the rules makes the contract subject to the rules within their own scope. If there are any doubt about that, Clause 2C gives the answer. Irrespective of my learned friend Mr. Chan's submissions this morning, the one thing Article 2C does do is indicate that the parties do not intend there to be any responsibility after discharge. Whether that's effective in a misdelivery case, the cases suggest not, the Motors case that my Lord Justice Legate referred to. But nonetheless, where the contract has an express term in the words of Clause 2C, can it really be said that the parties, by incorporating the Hague rules or the Hague-Visby rules, most of which, or a large percentage of which, are concerned with imposing liabilities on the carrier, did they intend that regime to apply after discharge when they've expressly provided no liability after discharge? In our submission, one only has to consider that to see that my learned friends can't be right. And that is all the more so in the case of an implied term. And I put the matter yesterday, if one asked the officious bystander, did these parties who've got an express clause in the wording of Clause 2C obviously intend to incorporate, in relation to the period after discharge, a package of rights and remedies and responsibilities on the carrier in the form of the Hague rules? The obvious answer is, well, no, they've excluded that. And that brings me on to Clause 2C and my learned friend Mr. Chan's submissions. There's little I can add to what I said yesterday, nor in our submission little that needs to be added. Our submission is that the wide wording of Clause 2C makes it clear that the parties did not intend a Hague-Visby or Hague regime to apply after discharge. They make that clear by the words that essentially say no responsibility or liability in circumstances where if the Hague or Hague-Visby rules apply after discharge, then there are responsibilities and liabilities imposed by those rules. So as Lord Justice Longmore held in MSc Amsterdam, a contractual clause sufficiently making that clear will oust the limitation provisions, in that case package limitations, in our case time limitations. We say there's no difference. So all that really matters is to look at Clause 2C, look at the provisions in the MSc contract that I took you to yesterday, my learned friend took you today, and say, is there any material difference? And there are a lot more words in the MSc bill, in those clauses that my lords have looked at today, but the import of them is the same, a complete exclusion of liability after discharge. Unless I can assist further, I apologise for very slightly overrunning my time. Actually, I should just check with my learned friend. Those are our submissions. I'm very grateful to you.
Thank you very much. Well, the court is very grateful to counsel for their skilled submissions in this interesting appeal, and we're also grateful to those who have assisted counsel in the preparation of the appeal and the documents which we have to consider. The court will take time to consider its determination of these matters. Thank you.